Hello, this is Vin Banj from Tella Westing. Welcome to our webinar today. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection and cyber and information law issues. Our regular attendees will be very familiar with our previous topics, which have included looking at challenges such as the GDPR, the General Data Protection Regulation, and we've looked at that in its entirety, but also in its various constituent elements over time, and that topic will no doubt continue to be a feature for webinars to come. And we've also looked at areas such as direct marketing, human resources, data privacy challenges, data security and breaches has also featured alongside some of our more international focused sessions, whether it's updates or looking at specific regional issues such as the EU and US Privacy Shield. So recording of those webinars are available if you missed them and if you still wish to engage with us on those particular topics. In fact, there are some 30 plus webinars to access in our virtual data protection learning bank. So today we will be continuing on the theme of data security and international. So we'll be looking at developments in particular across Asia. And given the topic and the Asia focus, we've switched the time of our broadcast to make sure that this is actually more timely for all our attendees in Asia. And we know it's a little bit early for our attendees in Europe, but however, we're delighted to see a good, strong attendee rate from Europe as well as Asia on this particular webinar today. So as you'll see from the slide on the screen, Tella Westing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering. And we do so from our office footprint, which spans across not only Europe, Northern, Central and Eastern Europe, but also the Middle East and, of course, Asia, the theme of our webinar today. And we also have our representative offices in the US. And we've listed more details about the firm and the slide deck for your reference. So today's webinar is brought to you by Tella Westing's International Data Protection Practice. Now our team advises on all aspects of data protection and information law, and we do so from the office footprint that I've just outlined for you, which is a global 22 partner-driven team. It's also, quite importantly, complemented by our international network of data privacy law specialists to make sure that we can provide you with a true global one-stop shop offering for data, information, and cyber law issues. At Tella Westing, we have a dedicated microsite that's specifically for all things data protection, and that is our global data hub. From this site, you'll be able to get access to a lot of material which many of our attendees and users find incredibly useful, and we've had a lot of positive feedback to that effect. You can access a news weekly update, which really cuts through a lot of the privacy noise that's out there and focuses on the key issues of the week for you. We look at topical issues where we take a regular look at those issues that are raising concerns or challenges and provide you with more of our thought leadership. We can also allow you to access webinars or register for webinars. We'll also see a whole range of webinars and events that are taking place around Tella Westing around the world, events that have taken place so you can see materials, but also those forthcoming events that you can register for and also access those archived webinars that I mentioned just a moment ago. We also have lots of features that you can access through the Global Data Hub, including an increasing number of country pages for increased coverage on an international basis against this very relevant topic. We also now have our Global Data Protection Guide, which you can access from the Global Data Hub as well as the main data protection and the main TaylorWesting.com pages. If you haven't seen this before, I really would encourage you to have a look. We've had some tremendously positive feedback. This is a new product that we launched, a new guide that we launched only last month. It provides a comparative look on data protection laws in over 65 countries, ranging across all the different continents where there is or where you are likely to be looking for in terms of a data protection law. And you can slice and dice the different views that you're after, depending on what's really important for you, whether you're looking at the key data protection questions applicable, or whether you're looking at data protection issues for a particular country, or whether you want to apply more of a matrix approach and look at multiple questions for multiple countries. And of course, the flexibility of this tool is that you can then export the results to yourself by email and share as you see fit. So if you haven't seen that, I would encourage you to have a look and also give us your views as you use the product, as I'm sure we will continue to develop that over time. But we are genuinely proud to have launched this. This is a global data protection guide brought to you by the global data protection team at Tella Westing. So my name is Vin Banj. As I mentioned, I'm the head of the data protection practice based here in London. I'm delighted today to be joined by my international colleagues to bring you this Asia-focused update. And couldn't be more relevant in this growing area of cyber and data breach law in particular. And I'm delighted that I'll be joined by Dr. Michael Tan, one of my colleagues based in China, who is developing and growing his expertise and his team's expertise in this area as the topic has grown in stature and in development in China in recent years. Michael has been developing his and his team's expertise and has been right at the forefront of those developments from a China perspective as well. I'm also delighted that Rizvi Wan, my colleague based in Singapore, is joining us today as well. Rizvi has for a number of years been focusing on data protection as we saw the advent of data protection laws introduced some 5-6 years ago in Singapore, but also as we've seen the wave of new and updated data protection laws spanning across Asia and the ASEAN network and the ASEAN countries in particular. So delighted that my international and local specialist colleagues can be joining us today. And it's important that they join us today because this isn't purely just speculatively updating you with a thin veil. We're hoping to really give you some good updates and some good outline on what's happening in China. And in a moment, I'm going to hand over to Michael, who will talk to us about some of the cybersecurity issues and the increasing nature and the escalating nature of the obligations and the impact of that we're seeing across China. And of course, many of our attendees are not only businesses based in China, but also international companies that will have operations or maybe thinking of expanding their operations or their footprint into China. So a lot of the points that we're going to explore there are going to be very relevant in that regard. Then, once Michael has finished updating us on that, we will move on to looking at developments first in Singapore, but also, as I mentioned, Rizvi's expertise and Rizvi's role is to really provide us with that hub of coordination and our range of specialists across the whole ASEAN and generally broader Asia regional coverage. So Rizvi will also be giving us an update of what's happening in some of those other key jurisdictions across Asia, such as Malaysia, the Philippines, Vietnam, and also into Korea and Japan, and further down into the Oceania region as well. So they'll be moving on and exploring those issues with us today. In our usual fashion of webinars, we have some polling questions to gauge your views. So please do click away when it comes to the polling questions. As always, the representation of what you poll is not against you personally or your organization personally, but it allows us to share the aggregate views. So all of our attendees become aware of what their attendees are thinking, and we can give you that aggregate view of polling against those specific questions. So we'll have those polling questions to the end. As always, please do send questions through during the course of the webinar. We will do our utmost to answer them or follow up with you afterwards if we don't get time to answer those. But please do send those through during the course of the webinar, and we'll do our utmost to cover those as we usually do. So without further ado, I'm going to hand over to Michael Tan to lead us through the developments in China. Michael, over to you.
Thank you, Wayne. Hello, good afternoon and good morning, everybody. Very delighted to have the chance to share with you our latest observation on the ground regarding the very particular China situation, and particularly its impact on your business operation in China or with China. And here actually, you don't need to record or write down anything. We will share with you our slide later on, which actually contains quite a lot of information. I'm trying to condense them a bit because we only have 20 minutes to run through this. And I'm the one heading the TMC practice and data protection practice on the ground, so you are most welcome to always approach me for any questions. Now I'm showing you a map of China, which is actually, this is a map I used 2 years back when I was presenting on the national security law at that time, which was overhauled. And now I'm using it here just also to, I'm now also using this to illustrate a bit of the cybersecurity concerns from a Chinese perspective. I mean, from a Western perspective, there may be a lot of confusion and issues, but solely from a China perspective, as you can see, there are a lot of issues, crises, or pressures, military pressures from the outside, which make China very nervous. So they tried to formulate some rules to tackle these new challenges in the new era. And this is not a simple law. Actually, as you might have known in China, the political system is so special, and the execution efficiency actually is very high as far as the party wants it. And cybersecurity topic, this is exactly one of that topic which is being pushed up now by the top leaders. As you can see from the left top, there's the party flag, and then you see this CPC, Chinese Communist Party National Security Commission. This is a very high-level commission which is now having all the security-related issues and concerns. And China is really building up a very comprehensive national security system. And among this system, cybersecurity is one of the cornerstone. And on the right side, I would like to draw your attention to the box in the right bottom, where there is a new agency being created. It's named Cyberspace Administration of China. This is its governmental name. It actually has another name, which is called the Cyber Affair and Informatization Matter Office of the Chinese Communist Party. So it's one agency, but serving for different purposes. And this very simple fact illustrates that this is going to be a very powerful agency, although it's less visible to the outside. But from the various new legislative moves, which I will show you later on, you will see that this new agency, which we call a CAC, actually is getting more and more important in the Chinese political landscape. And looking a bit at the legislative development, the cybersecurity law was rolled out as a form of draft already in 2015, 2 years back. And then it underwent a 3 review and becomes effective June the 1st this year. And as you could see from the right side, you see a lot of CAC names, right? And this exactly is a fact, as I just mentioned, that CAC is taking up the power, formulating a lot of rules in order to reach out and extend its territory. And such rules are not only rules which they are supposed to create, but actually via this kind of quasi-legislative power, CAC is also extending the interpretation of the cybersecurity law, which I'm going to quickly show you later on when we talk about data export clearance. Just to move on, I mean, in China, when talking about all these legislative and legal topics, always important to have a look at a bigger picture. And here I'm showing you some of the more personal interpretation on what is standing behind this. Just put it in a nutshell. On the one hand, China is really getting more and more important in the global economic arena. And on the other hand, China does see the concern in terms of security, because the American Prisma scandal really scared China. So they are launching a lot of IT-related security campaigns. Like the recent famous one was this DIOE campaign, by which they try to drive out the American products from China. But in reality, it's so difficult for them to find a very good local replacement. So in the end, it becomes something in between, a kind of compromise. And solely from foreign investment and foreign operation perspective, I guess quite many foreign operations might feel that the red copy treatment in the past is gone to some extent, and you are facing more and more operational pressures on the ground. This is a matter of fact, but on the other hand, there are also some very promising signals ahead, because the market is going to be more and more open, so you just need to get more adapted to that. And then another very important aspect in terms of cybersecurity is that the legislators, they are not less experienced, they are also learning. And this you can see then later on when I talk about the data export control rules. So now let's move to part 2. What will be the implications about this new law? Actually, when we talk about this new cybersecurity law, many people will be talking about a concept of CIO, which stands for Critical Information Infrastructure Operator. Many foreign companies are claiming that this is a very broad definition which can catch all, but actually, if you are Chinese, when first reading the cybersecurity law itself, it's very difficult to draw a conclusion that this law has any relevance to you, because when looking at the scoping of CIO, first, there's no definition. It only lists certain exemplary industries and features where a company may qualify as CIO. As I shown here on the left side, this actually refers to those really very key and major and critical industries where anyway foreign companies are not supposed to have a controlling position. So why it bothers? I mean, what's the relevant to foreign operation? Information service, as underlined here, may be relevant, but still, I mean, this public communication, energy, all this sounds to be referring to those big state-owned companies, but not really a ground where foreign players will be having some relevance there. On the right side, you might see some relevance, which is very vague criteria as far as anything goes wrong in your operation, which might damage national security or national economy or people's livelihood or public interest. It might become a CIO, but that still sounds too far, right? So solely reading the law itself would be difficult to draw a conclusion that this is something relevant to a foreign operation. And technically speaking, the law says that CIO will be subject to some data export control measures. There's also local storage requirement and obligations. But again, if CIO is not relevant to me, then why bother? And now here comes the real stuff, the new draft measures on data export clearance, as shown in the bottom part, which is not yet effective, although it should have been taken effect on June the 1st, but not yet. And what's new here? Having a closer look. And actually, under this law, it's no longer talking about CIO. Actually, it's the CAC, this new cybersecurity agency, is extending its scoping. So looking down, network operators, which is defined to be network owner, administrator, or service provider, which is a much broader scoping. As far as your network operators, you might also be caught. And then more scaring will be these other individuals and organizations. They are also subject to this local storage obligation. Then, obviously, such draft measures on data export control is going very far beyond the cybersecurity law itself. And what's the procedure implication under such export control mechanism? As far as the data fulfilling any one of the below criteria in the bottom part, you need to handle an administrative export clearance procedure. And looking at the criteria, data involving over 500,000 individuals, maybe sensible, and data size exceeding 1,000 gigabytes. That sounds, quite not that much matching the business reality, because in a big data era, this can be easily exceeded, and they may apply this on an accrued basis. Then it's even more making business more vulnerable and exposed to this new regulatory requirement. Also, some other sensitive stuff, the rest are more understandable. But looking at the underlying part, exporting data by a CIO, actually this item is the only item which is supposed to be regulated under the cybersecurity law. But now, as you see from these draft measures, CAC greatly extend its application scope. And we're moving to the next slide. So very much of a big surprise that CAC extends its scoping. So data not allowed to leave China. There are certain type of data which are not allowed to leave China, and the description here are easy to understand. Something new is that data export does not satisfy requirement of laws, regulations, and rules. Again, the Chinese laws and regulations always love to have this cover all clause, and which make it even more vague and ambiguous. So practical issues, indeed, as I mentioned at the very beginning, the regulators, they are inexperienced. So how to really adapt your business to this, because quite many obligations may not really fit business environment. This needs to be noted. And, sorry, my slide shows a bit slow, so you have to be patient a bit. Okay. So now talk about the export clearance measures and procedures. Here in general, we are talking about two sets of procedures. One will be self-assessment. As far as any of your data need to be exported, you always need to do this assessment, and it will needs to be done annually. You need to file the result, and if there's any major change, you need to reassess it. And whenever your export of data touches upon those criteria, as I just mentioned, like more than 500,000 individual data or more than 1,000 gigabytes, then you need to go to the authorities to do an administrative assessment. This is very cumbersome. They have 60 working days to do this, which might simply kill business in reality. And then main aspects of assessment, these are more detailed, which I'm not going to talk about. So in general, it's creating quite some burden for business. And then when talking about the impact, we should not solely look at the cybersecurity law. And actually, we talk about a whole cybersecurity regime now being built up under the new law. And a very relevant aspect would be, first, the cloud services and encryption services. These are going to be affected now by some other pertinent moves by the legislators. For example, there's now this new rules circular by the Ministry of Industry and Information Technology, which is the watchdog for all telecom business. They are now banning certain type of cooperation models to run cloud business. The background is that cloud service very much likely will qualify as value-added telecom service under Chinese law, which means that foreign investment, you cannot have more than 50% stake in the operation. But for quite many foreign operations, they are so much used to international brands of cloud services. Then for such service providers, they need to team up with the local service provider who holds a proper license. And in the past, the local partners, they only grab a very small part of the margin, and where the foreign service provider is presenting their brands and products to the customers. But now this model is not going to work. So this will have an impact on the service provider, and then indirectly on the customers who are using such service providers, such services. And also, I mean, here I'm just reciting certain cooperation models which are explicitly barred by the new circular of MIIT. As you can see from these prohibited items, actually those models in the past which give foreign players a very good margin may be gone, which then will have an indirect impact on the business users, meaning customers. So next, now will be use of VPNs. You may have heard about from headlines or news reports that this is to be cracked down. Why? I mean, everybody having the experience staying in China will know that quite many foreign services like Google, Facebook, you just cannot access from within China. Why? Because Chinese government, they have a censorship system, so they deployed a kind of a so-called Great Chinese Firewall to filter all traffic in and out of China. And this is greatly slowing down a lot of business traffic as well. And in reality, many people are using VPNs, including companies, to avoid latency issue and to improve connection speed. But this is now going to be impacted by this. The lucky side is that the regulators, they clarify that for companies, if you are using VPN to structure your IT infrastructure globally, only for internal use purpose like intranet or emails, that should be fine. But if you are using that in association with some other external services, then that would be a problem. So, and it cannot be excluded that this is going to be extensively interpreted and applied in practice. So we have already heard about some very practical problems now faced by our clients in reality due to this, which is causing some real business hurdles. And then when talk about violation, there will always be consequence. You only need to know that breaching cybersecurity obligations now will also be subject to criminal liabilities, which will be up to 3 years detention and fine. And even there was a recent SPC interpretation stressing this, which further relates to breach of personal data cases. And administrative-wise, cybersecurity law says that if you refuse to fulfill certain cybersecurity-related obligations, you might be fined up to 1 million, which is already double than the fine available under the amended Consumer Protection Act, which was only about 500,000, all relates to data breach cases. And civil liabilities, that depends very much on the concrete case, which I will skip here. So just to show you some relevance here, because when talking about all these things, so how are they relating to your business? Here I'm showing you 4 typical business scenarios where all this impact might be relevant. First will be cloud solutions, Industrial 4.0. Actually, we are part of an Industrial 4.0 closed-door discussion working group, which exactly is talking about the impact. And still, I mean, the business side is now working, lobbying the regulators, trying to soften the position a bit, because cloud solutions indeed can be quite critical to success of a lot of foreign operations here. Use of internet and VPN, as shown on the right top side. This I already explained that they are not targeting internal intra-group use, but there could be some problems in case this is misused by staff and employees. That then closely relates to internal control, as shown on the left bottom, where you need to build a proper internal control system to regulate that. And then on the right bottom, contingency management. So you need to have certain protocols in place. This is similar to a dawn raid situation where your employees, they need to know how to respond to all this. And then the last slide will be talking about suggestions, takeaways. Because this is something very new, so raising awareness, this is always key in order to attract attention from the high management, and in order to implement a systematic approach without support from the top, it will be very difficult. And joint force in lobbying and rule influencing, this is a typical approach in China. As we have seen that CAC is already softening its position regarding certain data export control requirement, which we won't talk in detail here. But the second draft regarding data export control is already much, much better than the first draft, as we have seen. Internal process to be prepared that I mentioned. And then in the end, I just would like to stress that in order to adapt to this new situation, you just need to throw some resources into this. It's not something that you simply just watch and wait and see, but rather you need to get prepared at an early stage, because otherwise, the cost in order to remedy something would be much, much higher than preventive cost. So in the end, all sounds very scary, but this is still the market. So from business side, there will be demand. You just need to embrace all the new challenges. So this is all my part, and I'm now going to hand ground to my colleague Rizvi to talk about the ASEAN situation. So Rizvi, yours.
Hello everyone. Thank you, Vin, and thank you, Michael. Good afternoon, everyone. My name is Rizvi, and I'm here to present the major developments in data protection and in cybersecurity in the rest of Asia. Now, cybersecurity has taken on a whole new level of importance this year, especially since many Asian countries were adversely affected by the WannaCry ransomware attacks in May and, to a lesser extent, by the Petya ransomware attacks in June. Now, we will start with developments in Singapore, followed by those in Southeast Asia, parts of North Asia, and rounding off nicely with Hong Kong and Australia. A few trends may become apparent. Firstly, regional cooperation amongst the enforcement authorities will be essential. And secondly, some countries are beginning to implement detailed data export rules. The authorities in Singapore are taking cybersecurity very seriously. Since 2005, when the first cybersecurity master plan was launched, the protection of cyberspace has always been treated with a sense of priority. In 2016, the Cybersecurity Agency of Singapore, the CSA, was created and is the government agency dedicated to oversee cybersecurity. In late 2016, the Singapore government launched the Comprehensive National Cybersecurity Strategy. It was at this same time that it was announced that a new cybersecurity bill would be issued very soon. Now, on 10 July 2017, last week, the CSA, together with the Singapore Ministry of Communications and Industry, introduced a first draft of the new Omnibus Cybersecurity Bill. This cybersecurity bill takes a holistic approach to making Singapore resilient against cyber attacks, especially for critical information infrastructure, or CII, in Singapore, and seeks to achieve 4 objectives. Firstly, to provide a framework for the regulation of CII. This formalizes the duties of CII owners in ensuring the cybersecurity of their respective CIIs. Next, to provide the CSA with powers to manage and respond to cybersecurity threats and incidents. Section 15A of the current Computer Misuse and Cybersecurity Act of Singapore, or the CMCA, provides some existing powers related to cybersecurity. These powers will be enhanced within the cybersecurity bill, and specific powers will be vested in CSA officers as sitting powers. Next, to establish a framework for the sharing of cybersecurity information with and by the CSA and the protection of such information. Finally, to establish a light touch licensing framework for cybersecurity service providers. Amongst other things, these service providers will be expected to adhere to a code of ethics. Now, the period of consultation for the draft bill will end in early August. The Singapore authorities have given a very strong indication as to the direction and the manner they will take in regulating cybersecurity in Singapore. Other significant developments in Singapore include the following. The CMCA was amended in April 2017 to criminalize certain conduct as cybercrime. 4 key changes were made. First, the act of dealing in personal information obtained via an act in contravention of the CMCA is a criminal offence. Handling stolen data, if you like. Next, the act of dealing in items capable of being used to commit a CMCA offence is a criminal offence. Tools that are capable of being used for hacking. Next, CMCA offences with serious harm to Singapore will have extraterritorial application. And finally, charges for multiple CMCA offences will be aggregated with a view towards applying enhanced penalties when the combined acts result in high aggregate damage. The Personal Data Protection Commission, or the PDPC, is the body entrusted to enforce privacy obligations under the Personal Data Protection Act of Singapore, or the PDPA. There has been an increase in enforcement decisions of the PDPA. 2016 saw a total of 22 enforcement decisions issued. So far, 12 decisions have already been issued in 2017. Significantly, 2 discernible trends can be seen. Firstly, decisions and practice directions of other data protection enforcement agencies are treated as having persuasive value. Recent decisions of the PDPC have referred to decisions of the UK's ICO, decisions of the Office of Information and Privacy Commissioner for British Columbia in Canada, and to the Code of Practice of the Office of the Privacy Commissioner for Personal Data of Hong Kong. We believe there will be more to come in future decisions. The PDPC has also recognized the need for international cooperation, especially where a party who is in breach of its obligations under the PDPA is based overseas. This is hardly surprising given the practical difficulties, but nonetheless demonstrates the international nature of the industry and the need to have international cooperation amongst enforcement agencies. Developments within the PDPC and the CSA. The PDPC is also establishing a framework to improve the knowledge and skill sets of cybersecurity and privacy professionals in Singapore. They have put in place a series of certification programs designed to enhance the training and standards of data protection officers in organizations. The CSA has formalized Singapore's relationship on cybersecurity with 2 more countries in 2017, demonstrating the emphasis on international cooperation. In June, the CSA signed an MOU with Australia to promote cooperation between the 2 countries on cybersecurity. In July, Singapore and Germany signed a joint declaration on strengthening cybersecurity cooperation. These 2 latest joint collaborations add to the existing previous 5 MOUs of the CSA with France, India, the Netherlands, the United Kingdom, and the United States. Now, industry players are not slow to react to the changes and have been busy with their own initiatives. The Monetary Authority of Singapore, or MAS, has turned to innovative technology as a means to enhance security measures. In June, it was reported that the MAS, in collaboration with a number of banks and blockchain technology firms, has successfully completed phase 1 of tokenizing Singapore dollars through an Ethereum blockchain. We foresee there will be more to come of these innovations through technology. I will next cover some of the major developments in parts of Southeast Asia. For Malaysia, the major development was in data export control rules. In April, the Malaysian Personal Data Protection Commissioner issued a public consultation paper setting out a wide list of countries to which personal data originating from Malaysia may be freely transferred. The draft list of approved countries and regions include the European Union, the United Kingdom, Canada, and Switzerland, amongst others. In Asia, the countries that have been provisionally approved are Australia, China, Japan, Philippines, Korea, Singapore, and Taiwan. In the absence of this wide list, data users in Malaysia must rely on the exemptions currently available in the Personal Data Protection Act of Malaysia. As part of the National Cybersecurity Plan 2022, the Philippines has launched a new comprehensive national cybersecurity strategy framework. The 4 primary goals of this framework are to assure the continuous operation of the critical infrastructure, public and military networks of the Philippines. Next, to implement cyber resiliency measures to enhance the ability to respond to threats before, during, and after attacks. Thirdly, to have an effective coordination between law enforcement agencies. And finally, to establish a cybersecurity educated society. Now, in Vietnam was the first country in Southeast Asia to put in place an omnibus cybersecurity law. This took place in July 2016. This is the first comprehensive law ever issued in Vietnam on the security of cyber information, which is defined as information exchanged in a telecommunications or computer network environment. Key aspects of the new law include provisions covering assurances for the safety and security of cyber information, the protection of personal information in the network environment, protection of information systems and infrastructure, standards and technical regulations on information security, and emergency responses. Now, it remains to be seen how this new law will be implemented in practice. In North Asia, I will cover developments in South Korea and in Japan. In June 2017, South Korea became the 5th member economy to join the Asia-Pacific Economic Cooperation's Cross-Border Privacy Rules System, in short CBPR, a voluntary but legally enforceable code of conduct that aims to facilitate secure data transfers and e-commerce between parties to the agreement. The CBPR system is a regional multilateral cross-border data transfer mechanism, and enforceable privacy code of conduct developed for businesses by the 21 APEC member economies. With this move, the South Korean government hopes to enhance the data export regime of South Korea. Japan affected substantial changes to their regime of protection of personal information in May 2017. I will highlight two of the changes. Firstly, any offshore data controller which acquires personal information of data subjects in Japan for the purpose of supplying goods or services to those persons will now be subject to the new law, even if it does not handle any personal information within Japan. Also, the new law will set out detailed course of action to be taken by data users following the leakage, destruction, or damage of personal information and other specified instances of data leakage or loss. I will now round up with the position in Hong Kong and in Australia. Now, the regulatory authorities in Hong Kong have had a busy first half of the year. In May 2017, the Securities and Futures Commission of Hong Kong, the SFC, issued a consultation paper proposing guidelines for reducing and mitigating hacking risks associated with Internet trading. Amongst other things, the aim of these guidelines is to set minimum baseline requirements or standards expected by the SFC from licensed entities engaged in Internet trading. The Hong Kong Monetary Authority, or the HKMA, is in the midst of implementing its Cybersecurity Fortification Initiative, or the CFI. The CFI is intended, amongst other things, to assist financial institutions to evaluate their cyber resilience. This initiative started at the end of 2016 and is ongoing. The assessment phase of this initiative is expected to be completed by September of 2017, or for those institutions graded as having medium to high risk, then by June of 2018. Now, in February 2017, Australia introduced a mandatory data breach notification scheme in their privacy and data protection legislation. The amendments will likely come into effect 1 year after the bill receives the royal assent. So in the meantime, organizations will work together with the Privacy Commissioner to get ready for this new data breach notification regime. Now with that, I've come to the end of my update for Asia. Thank you very much for your attention.
Thank you very much, both Michael and Rizvi, for the very helpful coverage and outlining of the developments across numerous major economies across all of Asia, from the very north to the very south of the whole region. There's a lot for you to cover there, so I'm incredibly grateful that you've managed to do that. And also it highlights that there are so many changes taking place and so many developments that all impact across the area of technology, infrastructure, the movement of data protection, and of course security and cyber. So grateful that you've done that for us today. And really it's on that theme I just want to continue on and poll a few questions, just 3 questions, but be delighted for the audience to click away and tell us their views on these, and we'll just share them back. The first question I wanted to look at in particular is around the issue of breach readiness. And the question there is, will you have to upgrade your breach readiness plans to address the additional issues that have been raised in the webinar today. So given what you've heard today, do you think that will result in an upgrade to your breach readiness plan? So click A if you think yes, but first you're going to have to raise more awareness at senior executive level in terms of the developments that we've outlined to you today. Or no, if you think actually that your existing plans already address what you've heard. Or C is yes, you are going to, because your plans, you believe, will not extend to some of the new requirements and developments that you've heard today. So A, B, and C in relation to whether or not you feel you need to upgrade your breach readiness plans. The second question is around breach readiness plans and how you deal with those as an organization. Often we hear that there are so many different approaches, and often approaches have been regionalized. So I just wanted to test with you today is whether your breach readiness plans are separated in terms of Asia from the Europe and also the US, because often we tend to see US and European data breach plans sort of addressed within the same documentation. So how do you deal with this? So A, yes, if it's a regional approach, so it is separated. No, if it's one global approach, and that's what you want to continue to have, that one global approach. Or C, and again, a very valid answer, if you're not sure what the approach is, I think, again, that's important for us to know, because that also reveals a lot in itself. The third question we wanted to poll with you today is really around testing cyber plans. And when you test your cyber plans and your breach readiness plans, do you involve your Asia colleagues and businesses in that fire drill, in that test that you have? Again, often we see testing done at sort of wherever the center of gravity within an organization is for tech or for part of its leadership. And so I just wanted to gauge from you today as to when you test that, whether you do actually involve your Asia colleagues and businesses to take on board their specific angles as well. So yes is answer A if you do that, and it's a regional approach when you test it, or B if you have one global approach, please click onto B, or C if again you're not sure on what the answer is for your organization. Again, that tells a lot, so we'd like to know if it's C as well. So whilst we're just waiting for those to come through, I just wanted to pick up a couple of points, if I may. First of all, again, on the topic of breach readiness in terms of preparation, and breach readiness in terms of what are those fundamental steps you should follow when you have a breach. Some of you may already be aware, and we know you are because you've already engaged with us on our TW Tella Westing Cyber Response app. It's an app we launched within the last few months that allows our clients and selected organizations to have an app and make use of our app as part of your breach and your incident response team. And so again, I just wanted to make you aware of that, and if that is something you're not aware of, please do let us know if you have some more questions on that, or you will find more details accessible through the Global Data Hub. So that's just one thing I wanted to mention. We do have a couple of questions that have come in, and I'll turn to those questions in a moment, and we have some of the polling results that are coming through, so let me just bring you some of those. So the first question focused around, will you have to upgrade your breach readiness plans? And what will that hold for you based on what you've heard in the webinar today? So over 40% of you believe that yes, you will have to, but you'll need to raise awareness first. So there's quite a fundamental step for a significant proportion of you there. Likewise, and I guess quite comforting, some 40% believe you won't have to do that, because based purely on what you've heard today, you believe your plans are already global enough. So comforting to hear that there's 40-odd% believe that you don't need to change, but equally a significant number of equal size that believes you do need to do that, and you'll have to first raise that level of awareness. And the remainder is answer C, where yes, you have to wait and see what your plans will look like, because at the moment you don't think they will actually extend to these new requirements. So the amalgamation of answers A and C, which actually require the positive steps to be taken next, is clearly the majority view that's coming through there. On the second question, in relation to breach readiness plans and whether they are regionalized and separated, Asia on one hand and Europe, US on the other, or whether they really are global. Some 14% of you say at the moment you take a regional approach. A huge 65% of you have said no, you adopt the one global approach, which is incredibly interesting to see. And on one hand, not surprising given the nature of the global audience that we have today. But equally, we do have a significant other 20-odd% that have said they're really not sure how this is going to play out in terms of whether or not this is separated or whether this is one and all. So some interesting insights there around the regional approach versus global approach. And we are almost there for the amalgamated results for the third polling question, which is around testing your cyber readiness plans and whether, again, that's something you do on a regional or a global approach. So at some 30% of you have said yes, you actually do this on a regional approach. Some 45% of you say you adopt the global approach, and there is a near 20% that you're not sure on how that actually plays out. So again, it shows a differentiation in approach in terms of regional and global towards testing your plans and having your global colleagues, so in other words, including Asia alongside your Western colleagues and businesses in that sort of fire drill approach. My view, and the view that we often come across, is increasingly global organizations will need to move towards that global approach and making sure that global and Asia colleagues are included within this global approach, because the growing importance of what we've heard today and the growing importance of some of the factors of getting it wrong, particularly some of the criminal sanctions, show that actually there's increased importance on making sure that there is a global, inclusive approach, so including the developments that we see in Asia as part of global breach readiness and global cyber preparation readiness. I think that is what we would depart in terms of our themes going forward. We've had a couple of questions, and we do have just a couple of minutes before we close off. So I'm going to take these questions. The two I think we've got time to take are perhaps focused more towards you, Michael, in China. Let me start with and throw these questions at you, Michael, if I may. So if you can unmute to be prepared to answer these, that'd be great. So the first question is, if our company stores our business data on a local server in China, while our colleagues or partners may access such data stored in China, will this cause any data export concerns? And I think export is the point that perhaps this is particularly focusing on. What are your thoughts on that, Michael?
Okay, thanks, Vin. Well, it's a very good question. When we talk about this accessing data, presumably we talk about your head office or your foreign partners. They are accessing the data stored on a server which is located in China. Data storage is fine in China, but when we talk about export, we talk about digit flow. So this will mean that once anybody from abroad is accessing the data as stored on this local server in China, actually digit will be sent back to the respective terminal or desktop sitting located in a foreign jurisdiction. And this then will result in data export. So it would not be less simple that I just locally stored and then people can from abroad use the data as stored in China. Actually, the fact that you are accessing the data itself from out of China, this may already trigger data export concern.
Okay, thank you for that, Michael. So that's as I expected. The mere access points are similar to the way in which we interpret transfers under European laws. The mere access outside of the jurisdiction also raises an export consideration. So that's useful to have that clarification. I'm just going to sneak one more question in, Michael, for you again. So the question is, our servers are located in Hong Kong. Will this qualify any local storage requirements under Chinese law?
Well, I mean, it's a good question, actually quite often asked by our clients. I mean, if you have ever some experience in China or in Asia, likely you will know that Hong Kong is a separate jurisdiction from China, although politically it's part of China, but Hong Kong law is a different concept from Chinese law. So having server located in Hong Kong, this does not solve the local storage obligation requirement, meaning that only when your servers are located in mainland China, this satisfies the local storage requirement under Chinese law. And Hong Kong storage in Hong Kong will be deemed as foreign storage.
Excellent. Thank you very much for that clarification, Michael. So we have run up against our allotted time. So what I will just say to close off today's webinar, again, just to thank my international colleagues, Michael and Rizvi, for departing their knowledge and updating us on developments across numerous jurisdictions. It's quite a difficult task to cover there, given the shape and size and the complexity of the many economies that we've looked at today, let alone the complexities of the subjects that we've covered across today. So my thanks to you there. To reiterate a point that Michael mentioned earlier on, if anyone has any questions, the contact details for myself or for Michael or for Rizvi, you'll see on the slides and also on our Global Data Hub. Please do let us know, and we'll be happy to engage with you and talk to you about any questions or queries that you have. And also, we've released a batch of content yesterday and today, which covers in more detail the material that Michael in particular mentioned, and then very soon to follow, we will have more written content covering in a bit more detail the rest of Asia content that Rizvi was talking to today. So again, stay tuned. That will all be accessible on the Global Data Hub, and we'll bring that to you so you've got that written content covering those particular topics and jurisdictions. So I guess finally from me, thank you very much to our attendees for joining us today. We hope you found it useful, and of course, please do take a moment and complete the questionnaire that usually appears at the end of the webinar. We really value your feedback there. We have an ongoing program of events around the world, and so please do stay in touch with us. The Global Data Hub and also our local websites will bring you more information on all our events around the world. Our webinars, please do look out for those. Invitations will follow if you've already registered. If not, they will appear on the Global Data Hub. The 19th of September, we're taking a little summer break. 19th of September is our next international webinar, where we will be looking at the GDPR and its impact on commercial contracts. So we do hope you can join us for that webinar, and of course all our other events that are taking place across Tella Westing's operations around the world. But from now, from Michael in China, from Rizvi in Singapore, myself and the rest of the team here in London, thank you very much for joining us today, and goodbye.